You are welcome to Company and Partnership Law class. Today we'll be looking at Section 3 of Unit 5, which deals with documents relating to debentures. Session objectives. By the end of this session, you should be able to identify some selected documents relating to debentures, establish the relationship between debenture and debenture stock certificate, and lastly, explain how register of debenture holders are kept. Debenture and debenture stock certificate. Subject to the Central Security Deposit Act 2007 Act 733, a company shall, within 2 months after the allotment of any of its debentures, or after the registration of the transfer of any debenture, deliver to the registered holder of the debentures or a certificate of the debenture stock under the common seal of the company, or as satisfied by 2 directors and the company secretary of that company. Now let's discuss this particular provision. The provision says that subject to the Central Security Deposit. It means that this provision, in case there is a conflict between this provision as in the Companies Act and in Act 733, the provisions in the Act 733 will override that of the provision in the Companies Act, as we have discussed. So the law requires that once the debentures have allotted to the debenture holder, the company has a duty within 2 months after allotment to issue debenture stock certificate or debenture certificate to the holder, and this will be certified under the common seal of the company, indicating that indeed it is coming from the company, the company seal. Now, you should also understand that if not under the seal, then it should be satisfied by 2 directors and the company secretary. Apart from these people that the Act has mentioned, no other person can satisfy a debenture stock certificate. The question that you should be asking yourself is that what happens when the debenture or debenture stock certificate is defaced or destroyed or lost? The provisions of Section 85 subsection 2 of Act 992 allows or gives the debenture holder the right to request from the company to issue a new certificate of debenture certificate or debenture stock certificate to the registered holder. However, the requirement is that the person must pay a prescribed fee before the new certificate will be issued to him as a replacement. Now, what is the effect of non-compliance? I mean, if the company failed to issue the debenture stock certificate or debenture certificate, remember the debenture certificate indicates that you own debenture in the company, or you are giving loan to the company, and the debenture stock is whereby you have a portion, or you have contributed to the huge debenture that the huge loan that was given to the company. So your portion that you contributed will be the debenture stock, as we discussed in our previous discussion. or the previous, sorry, in a previous lesson. Now you want to find the effect of the non-compliance. If the company fails, what happens? The company will be liable to pay an administrative penalty unit of 250 penalty units. Remember, one penalty unit is equal to 12 cedis. One penalty unit is equal to 12 cedis. So if you want to know the total sum that you paid in case the company, if your company is failed to comply with the provision, the amount you pay is 250 penalty units times 12 cedis. You get your answer. Let's look at the effect of statement in debenture. So the statement that is contained in the debenture stock or the debenture stock certificate or debenture certificate, what is its effect? And the law provides that statements made in debentures or debenture stock certificates, including statements made electronically, are prima facie evidence of the title to the debenture of the person named in the statement as the registered holder and of the amount so secured. What we mean is that once your name has been stated in the debenture certificate or debenture stock certificate, on the face of it, you are the owner of that debenture. And it's also said that you have given the money stated on it as a loan to the company. Because it is a prima facie evidence that on the face of it, you can lead evidence to back that even though the person's name is on it, but the person is not the owner. Perhaps there was a mistake or the amount stated was not the original amount. So prima facie evidence on the face of it, you are the owner. But if the company can lead evidence to the contrary and the court is satisfied, you will not be held as the owner of the debenture, or in case the amount that was written on the debenture certificate is not the actual amount, then on the face of it, it is so, but the company can lead evidence to prove otherwise. Where a person changes the position of that person in reliance in good faith on the continued accuracy, so the person will change his position and rely on the statement in good faith that the statement is accurate. The law says that of the statement made in the debenture or the debenture certificate, the company is stopped in favor of the person from denying the continued accuracy of the statement and shall compensate that person for loss suffered by that person reliance on the accuracy, and which that person would have not suffered had the statement been or continued to be accurate. So this is what we are saying. If the company makes any statement on the share certificate, the debenture certificate or debenture stock certificate, perhaps the amount or the name, then the company will not be allowed to say, no, that amount is not right, or the name written is not the actual person. If the person rely on that statement to his or her detriment, in that case, the company is required to compensate the person for any loss suffered as a result of relying on the statement that it is accurate. So it is that the company has a duty to ensure that the statement contained in the debenture certificate or the debenture certificate is accurate, because Any mistake that the holder will rely on to act to his detriment, the law will prevent the company to say or deny the company to deny liability as far as that statement is concerned. So the company will be held liable for the statement contained in the debenture stock certificate or the debenture certificate. Register of debenture. The law requires that a company which issues or has issued debentures to maintain a register of debenture holders. So if you have issued debenture, you are required that you keep a debenture register. And this register, the register of the debenture holder shall be kept and maintained at the address at which the register of members are kept. So the register of debenture will be kept at the same place or address where the register of members is kept. And in the register of debentures, you have to indicate the name of the debenture holder, the amount given as a loan. Perhaps if it was secured by a collateral, you state all the necessary information that is surrounding the loan created or the debenture being given. You have to state. By way of summary, in this unit, we have looked at stock, debenture stock certificate. You also look at the register of debenture. You also show the relationship between debenture and debenture stock certificate. As I said, the debenture stock certificate is a certificate given to the individual members as a result of contributing to the big debenture or the big loan that the company is giving, or they are giving it to another company. And a debenture certificate is a certificate that represents the total loan given out. You also indicated that where there's the debenture certificate or the debenture certificate, debenture stock or debenture certificate is destroyed or lost, the registered holder can apply for a new one to replace it, however, subject to payment of a prescribed fee. Thank you. Have a nice day.